There was excitement and jubilation yesterday when President-elect Bola Ahmed Tinubu touched down at the international wing of the Nnamdi Azikiwe Airport, Abuja. His supporters in their numbers gathered to welcome the president-elect, who has been away from Nigeria on a 4-week vacation. Tinubu left the country for France on Tuesday, March 21, to rest and plan the transition program ahead of his inauguration on May 29. While he was away, there have been questions around his dual citizenship, which wasn't declared by the president-elect when he was running for office. The dual citizenship allegations is the latest in the series of controversies surrounding the president-elect, Bola Ahmed Tinubu. While his critics claim it is enough to bar him from the presidency, his supporters think otherwise. Joining us on this show to discuss this is Michael Aondoakaa, former Attorney General of the Federation and former Minister of Justice. Welcome to the Morning Show.
Thank you very much. Good morning.
Well, thank you very much indeed. Well, I mean, this big issue about dual citizenship, I thought that the matter had been settled in the Boluga case, and that the Nigerian constitution says you can have dual citizenship once you meet the qualifications as stated in sections 25 to 28, 29 of the 1999 Constitution. But Nigerians are still bringing up this conspiracy theory that Bola Ahmed Tinubu, president-elect, is probably a strange creation that is neither Nigerian nor Guinean, and it's unknown. What is your advice?
Well, thank you very much. This issue is a little, I think it's a hype straight away, because I may ask, I've seen the petitions, especially that of the Labour Party, and it's not an issue in the petition. And I'm sure it's not an issue or a ground in the petition presented by former Vice President. Therefore, the argument is if it's not a ground in either of the petitions, the argument will be more an academic exercise or a hype. But assuming it's a ground of a petition, the position of the law, the confusion arose because of the conflicting judgments of the Federal High Court. The first judgment was that Calabar Court, which seemed to follow the decisions of the Court of Appeal. Then the judgment delivered in Rivers State, which appeared to deviate from the Court of Appeal. Let me make it clear that the judgment in Rivers ought not to have deviated from the judgment of the Court of Appeal under the doctrine of stare decisis. They have no right to deviate to follow the judgment of the Court of Appeal once the Court of Appeal does not have conflicting judgments. What I'm trying to say, if the Court of Appeal, maybe two divisions have conflicting judgment on the issue, a lower court may have a right to choose which of the judgment to follow. But here, there appear to be two judgments consistently by the Court of Appeal. The first was 2004, which was delivered, the lead judgment was delivered by Honorable Justice Onogan, who later became the Chief Justice of the Federation. And it was very crystal clear. A person who acquires citizenship by naturalization or registration cannot contest for president in Nigeria. But a person who is born by birth in Nigeria but acquires citizenship of another country, for instance, America, that was what was contained in that judgment. It has a right to contest election. There's no appeal to the Supreme Court to reverse that judgment. And that judgment was followed again by Justice Onyangi in 2014 in the case of Labour Party. The same way, if we are born by birth in Nigeria and acquire citizenship of another country, it cannot be a bar for you to contest an election. So those judgments are valid, and they seem to be the interpretation of the Constitution in Nigeria as of now. Therefore, it will be strange if we bring down the issue that the winner of the election, Senator Ahmed Tinubu, His Excellency, has another citizenship. You must prove first that he's not a Nigerian by birth. That is the first challenge. If you prove that, you cannot bring the issue that he's acquired another citizenship. If you prove that he was a Nigerian by naturalization or registration, then you can succeed to say he has acquired another citizenship. But in the absence of any other evidence to prove that he's not a Nigerian by birth, it will be extremely difficult. I have a feeling that the judgment in Rivers State, what must have happened that maybe the parties or counsel in those cases did not draw the court attention to the judgments of the Court of Appeal, which are binding on the Rivers State Federal High Court. Or the judge did not avert himself to those judgments. But if it was canvassed and the judge refused to follow the decisions of the Court of Appeal on the doctrine of following the doctrine of precedent and sterile disease, it's unfortunate.
Okay, in other words, it's safe to say that the argument about dual citizenship in this particular instance is of no issue, it's of no moment.
Precisely. First, it's not a ground of appeal, a ground of the petition. And if it's not a ground of a petition, at this moment, you can't amend the petition.
All right.
Maybe you can go and test it in the High Court, in the regular court, and bring an issue out of it. But for the purpose of the election petitions already filed, if it's not a ground, which I doubt any of the parties, because the information came after the petitions have already been filed.
All right.
I don't see how it is possible now to amend the petition to include that as a ground. So I am tend to agree with you that it's a hype.
Okay.
It does not. The petitions filed have very cogent grounds. If proved, can go other ways.
Okay. So
therefore, I don't think any of the lawyers canvassing will waste his time on a ground, an issue which the Court of Appeal has not been reversed by the Supreme Court.
all right.
Because if you even take it up, it will not go anywhere, because at the moment and the time he filled the form and submitted, if he had that dual citizenship, but he was born by birth in Nigeria, the judgment of the Court of Appeal gave him the lead way to do. Even if it's reversed by the Supreme Court, it will not affect an act which has already been done and completed, pursuant to a valid judgment which gave an interpretation in that manner.
Mr. Aondoakaa, another part of this matter, beyond, and thank you very much for explaining it and just detailing the fact that it's a non-issue, if I use the layman's terms. But another aspect of this matter is the fact that he might have perjured, because in his EC9 form, where he declared that he hadn't taken on voluntary citizenship of another country, he had indicated no. Could this be a matter, even though there's that question around who can prosecute, who can take up the matter, and would there be a willingness to do so in this case of a president-elect?
Well, if he did that, that is perjury. And the state is at the liberty of the state to do what. But mind you, if no action is taken before 29 of May, he will have the immunity and he cannot be prosecuted. But that, perjury is not a ground of a petition, because our position is clear. The grounds of a valid petition are contained in the Constitution and the Electoral Act. And I want to point out to you that if a ground exists in the Electoral Act which is in conflict with the ground specified for qualification or disqualification in the Constitution, that of the Electoral Act will have no moment. But of course, the Electoral Act has not introduced any other ground except the grounds and requirements of qualification and disqualification contained in the Constitution. Therefore, perjury is not there, so there's nothing you can do about it. And let me also go further to the issue of criminality. The criminality specified in the Constitution relates to a period which involves dishonesty, relates to a period of 10 years. Even if you are convicted in the Nigerian court or anywhere. And once you are not serving a jail term, that is, if you are serving a jail term, the 10-year grace is not applicable to you because you cannot come from prison to be a president. The Constitution says if you are serving a jail term and it's more than 10 years, you still be in a jail, you can't contest president. But if your conviction, after the conviction, 10 years has elapsed, you can still contest in the Nigerian election. Because if you go, you cannot expand anything that is specified in the Constitution that as a requirement for contesting an election of a presidential level or any election conducted by INEC. You cannot subtract anything from disqualification. That is the position of the law. When the Constitution specifies condition precedent, you cannot come and introduce another extraneous matter. It must be there. If there's a disqualification specified in the Constitution, you cannot add. So perjury is not one of the grounds there. I'll give you an instance. People were being disqualified on the ground of not paying tax. But when the matter went up to Supreme Court, or Court of Appeal in some instances, tax was not a requirement in the Constitution. Tax was not a requirement in the Constitution. All those judgments were obtained because it was not part of the Constitution. So perjury, as in this case, is a state matter. And but why I was a minister of justice, sometimes lawyers may not go to court because you don't know what the state may do. Assuming now the Attorney General say, okay, this is perjury, I'm charging you to court. Trial may not take just 1 month. Before you start the trial, 2 adjournments or 1 adjournment, or before arraignment, 29th of May will come in. You, as a prosecutor, you are stuck in because there's nothing you can do. The immunity is absolute. It's not qualified. So
okay.
The trial will abate.
Okay, Mr. Aondoakaa, there's a...
let me add another thing.
Okay.
Let me add another thing.
Yes,
if
sir.
you go for trial, and tomorrow the president says, I give him pardon, there's nothing. So sometimes prosecutors will be blamed, especially the Office of Attorney General will be blamed, but we also, in the course of process, we look at the environment. Because this office operates within a difficult terrain. You are dealing with politicians, and you have gone and got a conviction on perjury. Tomorrow the president says, I have pardoned him. There's nothing you can do about it. So sometimes you think that initiating certain action of this nature may be futile. You may not be able to succeed.
Okay.
But that does not mean I say people should not follow the law.
Okay, so Mr. Aondoakaa, two things I'd like you to state. Take us through the procedures of how perjury goes. Enlighten us more for the sake of public knowledge. No, secondly.
Perjury is an...
No, I have not finished asking my question, sir.
Yes.
Also, I want you to talk about the pick and choose that we see in public dispensation of justice. The fact that if cases concern people that don't wield power, it is fast-tracked and accelerated. But if it concerns people that wield power, what you just said now could apply. The fact that when you even put up the case and it goes through trial can be elongated and the likes and all of that. And also, I want you to also make a clarification and distinction between public morality and the ecosystem we live in Nigeria. The fact that a top candidate that finally eventually became president-elect didn't deem it fit to make a declaration of the fact that he hitherto had another passport, which is not a big deal, which is not against the law, in his form. That's a case of public morality. I know, yes, that might not hold water in the logicality of the law, but that's a case of public morality and public perception, which you cannot discount from societal ecosystem, because you said just now that court cases also have a look and feel of societal factors.
Well, thank you very much. Certainly, the issue of morality comes in. I will not deny that fact. It's a very big burden on society.
Morality is not law.
To see we leaders appear to violate the law. But you could see there's a presumption in law of a person is adjudged not to be guilty until he's proven. If you say that, stay until trial commences and he's convicted. I have agreed with you on the issue of the burden of morality. But I also have shown you the constitutional provision that we have to take the morality, if we have to take the morality to enforce into law, we must follow this. And the thing is that we arraign the person to court, the person take his plea, and if he says he is now guilty, then we have to bring evidence. Trial will go normally, and there will be conviction. It is expected. Speedy trial is the expectation of the whole country. But I pointed out the shortage of judges, the condition in which they live. You go to the federal high court now, or state high court, perjury is an offense that ought to be prosecuted by the police because of the recent decision of the Supreme Court. It's a state offense. Of course, that means the perjury was committed within the area of Federal Capital Territory, so it has to go to the state high court. And you go to one of the courts, you see courts list 29 cases. And then cases are called based on seniority. Sometimes it's not the fault of the prosecutor. The prosecutor will be a young lawyer. He goes there with the facts, ready to prosecute. Senior counsels come in, call the case up to order, because that is a procedure. If the most senior advocate will call his case, if he has 20 cases, he will finish his cases before any other person. By the time this is done, you will discover that time has lapsed, adjournment will be granted. This is occurrence as a result of inadequate staffing of the judiciary, because the manpower, judges ought not to have more than 5 cases on the court list, but you could see 29 cases. So such adjournments derail justice. And these are some of the things most of us have been advocating. Increase the number of judges for service delivery. A judge should not have more than 5 cases. Perception is there. You cannot doubt about that. Perception is there. And that is the thing that the public is complaining in everything. Mind you, when I came here on your channel before, I said something which the public has been yearning. And I say this is the time the judiciary and everybody involved in administration should look at it. Take, for instance, in the case of electoral matters. Our attitude has been to scrutinize the outcome of the result. This person scored this number. This person scored this number. And therefore, infractions that occurs are targeted on the result, who had the majority. But the main corruption that occurs in the electoral process is refusal to follow the procedure that leads to that result. And that is why at that time, that is what the public is yearning. Nobody will complain about an election if the procedure leading to those results that produce the majority result, which became the winner, and the procedure is followed. Nobody will complain. That if you see all the complaint has been that the procedure that's supposed to be done like this is not done. All the elections you have in the cases, the complaint may not necessarily be the overall result. But when we go to court, the target is to prove whether this result is correct or it is not, or this person scored more, forgetting that the main corruption is within the foundation which those results occurred. This is why it goes to the perception you are talking about. That is the perception that things should be done right. In criminal trial, the perception is that everybody should be equal within the law. And it...
Yeah, I just wanted to intervene.
Sorry, sir?
I wanted to intervene at this point. You brought up the issue of your last conversation with Arise News, which became controversial because you had cause to say you were misinterpreted. And I just want you to give us the opportunity for you to clarify your position with regard to 25%, whether you need it in 36 states
and
the federal capital. No, just a moment, sir. Just a moment. You know, I just want you to offer us very strong clarification. We have tried to, state what you said and to correct it. But you are here, so you have a chance. As for the issue about morality, well, with due respect, as you know, morality is not law. And so that's why the courts are always at variance with public perception, because the courts don't deal with morality. They deal with the technical details. Over to you.
Thank you. I never even in any way said morality is law. My previous interview with you also, I told you morality is not law. And I think we are all talking the same thing. Come to my interview. First, I never said amateur ought not to be. You asked me whether there were going to be problems. And I say, yes, there will be problems. And already there are problems. Once a petition is filed, it's a problem. It's a legal problem that has to be resolved by the parties. And I came to the issue of construction of and in between the issue of federal capital, the and there. And I laid the foundation and I said, look, directly in the interpretation of that particular section, which had in between the long sentence and the shorter sentence, has not been done directly. But it has been done in similar other cases. For instance, the issue of corrupt practices and non-compliance has been interpreted. And the interpretation of that and which joined corrupt practices and non-compliance was that it ought to be conjunctive. So that and has been interpreted. If you don't take that interpretation and fit into what is specified in the Constitution, wing to third of the Federation and federal capital, the law, if you take that interpretation, which the Supreme Court gave in 2006, to that and which joins corrupt practices and non-compliance and held to be conjunctively, that may be possible in case of that interpretation of the Constitution. Because the and has joined win 2/3 of the federation with federal capital, and you cannot do disjunctively. If you do disjunctively, it will lead to absurdity. But if you construct it conjunctively, it will make a meaning. That was what I said. And I'm still saying it. I've not changed that. I say, going to me, and my personal opinion, says that and in corrupt practices and non-compliance in the Electoral Act of 2000, which was interpreted in 2000, use that and to be conjunctive to make a meaning of the issue of corrupt practices and non-compliance. That means corrupt practices is at the same, and non-compliance are interpreted to be conjunctive. They follow together.
So I get your interpretation.
So,
the difference between...
And now, if you see, Supreme Court has not yet made a definite pronouncement on that and in between that section of 2/3 and 2/3 of the federation and federal capital. Supreme Court or none of the courts have made a definite pronouncement on that. And if they have not made, I don't see how they will not follow the decision they gave that and in non-compliance, in corrupt practice and non-compliance, it should be conjunctively.
Okay.
But maybe they can say it's disjunctive when it's applicable to the Constitution.
Okay.
Apart from that, there are also other rules of interpretation, which I don't know which one. And I said also that Supreme Court has a right not to follow its own previous decision. They can deviate it. The issue is there going to be a problem? I said, there's a problem. And now with me and Arise here, there's a problem because various people have filed a petition. That is the problem. There's another question I was asked, whether it's non-transmission or result will be a problem. I say it's a problem because INEC rules have constitutional flavor. So if you make rules, you ought. And there's Supreme Court decision that says it was a case of CPCs, so Supreme Court's INEC officials have a duty. They are duty bound to obey their own guidelines. And if they do not obey the guidelines, it's a violation of the electoral and the Constitution on the grounds of fair election. That's what I say.
Okay, sir, I get your point.
Thank you for giving that opportunity.
Yeah, sir, I get your point about
Yes.
what is disjunctive, what is conjunctive, and the rules of interpretation. I understand all of that. But for clarity purposes, are you saying categorically that Bola Ahmed Tinubu does not need to score 25% of the votes in the Federal Capital Territory? I guess that's how the ordinary person will understand it.
And I'm not saying that. And I'm saying that an opportunity has come again for the Federal Court for the court to give a direct interpretation of that and, which is in between 2/3 of the federation and federal capital. If they say it is disjunctively, it means he does not. But if they say it's conjunctively, then the meaning will be otherwise. But apart from these two rules, there's also mischief rules which the court can override what I'm saying and try to look at what is the purpose that is going to happen, what is the mischief. And I also mentioned to you that Supreme Court is a court of policy and law too, so they may look at other things differently. This is the position. But that section has never, interpretation of that section has not been the and in between that 2/3 of the federation and federal capital has that and in between those two, that sentence has never been interpreted. And I feel the time has come. We cannot gloss over the provisions of the Constitution.
Yes.
It is most important for us, any issue that comes out of the Constitution is to be interpreted based on the literal constructions of the wordings of the Constitution to lay a precedent.
Well, all eyes on the Supreme Court now. But, Mr. Aondoakaa, that leads me to my next question with regards to the role of the judiciary in election matters. I'm glad you talked about the procedure or the process and the reason why we have had so many uproars or challenges post-elections, because when the process isn't clear or isn't fair or isn't deemed to be fair, then you would have a number of people challenge the result of that process. But I want you to focus on the role of the judiciary. There's a trust deficit in the judiciary, especially amongst Nigerians and even politicians who are petitioning the courts. How do you think we can change what might be a perception or the truth. How can we begin to reform, change, and ensure that we restore that institution of the judiciary?
Thank you. Maybe the emphasis has been more on us lawyers that present our petitions. And the judges cannot go otherwise than what is requested of them to interpret. In most times, we go to court and we say at the conclusion, declare us the winner because we won majority or lawful votes. Basically, the judge will not concern himself to look at the lawful votes and who has majority of the lawful votes. And we restrict, but we have not. But I believe some of the petition presented him as we have not said nullify election on the grounds that procedure is not followed. To give the courts an opportunity to come out and say, look, you say this has to be done before if election will be said credible. You have not done it, so nullify the elections on those grounds. Most of the petitioners and us, our desire is to become the winner. So what we canvass in the court is what the court gives us. But I say maybe we lawyers that go to court, and when we feel, because sometimes we fear to attack the procedure, which is corrupted, because if we do that, we also will not be declared the winner. Election will have to be done afresh. But the procedure is as important than the result, or as important as the result, because a corrupt procedure has already corrupted the electoral process and then violates the Constitution because there cannot be a fair and fair election. If, for instance, if they say, INEC, open your polling unit at this hour, voting should be done like this. And then people stay on the queue in that area. Nothing has been brought. And the next day, there's a result with votes on it. Is the procedure followed? The result is there, but the procedure is not followed. If I next say, look, I want to declare my result, and makes regulation that if I finish at the polling unit, I will declare result there. I will transmit the result first. Then I will take the result to the collation center. And INEC does not do that. Has he followed the procedure? These are the minor things we have to try to clean the system. Because you cannot build a house without a foundation.
Okay.
Take the issue of Adamawa.
Okay.
Sir, let me finish. Take the issue of Adamawa.
Yes, sir.
Look at how the procedure was about to be violated. And let me commend the RIs and other news channels that rose to say condemn it, went viral, and they have to come back and do the right thing. But the issue was that don't care. Once it is announced, you go to court. Violating the procedure. You are not the returning officer. Returning officer, I joined collation to 11 o'clock. And then you, who is not a returning officer, comes by 9 and announces result. But that is something that attaches to the procedure. And quickly arise with the forefront, channels, and made sure that this is wrong, this is morally wrong. And INEC came and did the right thing by following the procedure. So in most cases, procedure is there, which could have given us a good result, but it is not followed. When the result comes out, we as lawyers go to court to challenge the outcome who has majority. We never seriously attack the procedure. And this is time we should lay a solid foundation in this country. Look at the procedure. What made you to change from what you did? Because the moment you change the procedure, you want to do a thing. And the Supreme Court have said in several cases that if there's a procedure of doing a thing and you deviate from that procedure, the end result you got should be vitiated.
Okay, I mean,
that's the position of law.
I'd like to comment.
That's the position of the Supreme Court. So if there's procedure for doing an election, and if suddenly it is deviated, don't we think it is important for us as lawyers to go to attack this procedure and make sure that next time the right thing is done?
I mean, Puka,
if we go to say, look,
it's a great place you landed in, because I just wanted to take you on that journey of your thought process now by also saying, and I earlier on talked about the pick and choose mentality. And I'm happy you put your hand just on Adamawa. If INEC can uphold its procedure in Adamawa, take me back to when the presidential election results were being counted and people reminded INEC of its same procedures on IREV. Then the question is, why did it not uphold it then? And those are the questions a lot of people are asking.
That is the kind of question that I told we should not be in a haste by saying, let us do everything and finish before 29 in my interview with you. And I said, look, let us invite the court to look at this procedure and give us a verdict whether this procedure could have substantially affected the result of the election. And I think this time people might have gone to court and attacked the procedure too. And let's see what the court will say. If they say it substantially affects the result, then people next time will not do it. But if you say it does not, and they have valid good reason to show that it did not affect the result, it is. And I alluded to the fact that in common sense, if you have said there's a procedure, we envisage unforeseen circumstances, calamities can happen. And if it does happen, you ought to tell the Nigerian public, this is what happened. And we could not, but the overall effect of Nigerians to have an election, which is good. I will do this one now, and they will be fair and fair. But if you keep everybody in silence, it is only the court that will interpret why you kept the Nigerians in silence. And that is why everybody is waiting the court. And I say, look, there's nothing wrong in the Nigerian judiciary. But it's how we present ourselves, our cases, and that now gives the outcome. So now things have come up more clearly now. You have said one of them. And I think that is also, I will say there's a problem. This is when I say a problem, there's somebody. You have said, this is from you. If now you should be quoted, what you said is a problem. What you said fits into the INEC regulations. Electoral acts from various sections of the Electoral Act, I think from 25, 47, 60 software talks about electronic voting. And then you come to Regulation 38, which talks about this, that you vote, results will be announced, and then copies should be scanned, sent to Beavers, sent to IRF, and then it is after you do that. To me, the others will say, look, there's a condition present for you to take the result to the collection center. Because I read the regulation and it used SHA. That means one condition is certain. You must send the results before electronically out to the portal before you go and submit. That is my opinion when I saw the SHA. But it goes back to the interpretation of the Constitution. Does this regulation fit into laws that can be obeyed? And if they are violated, it does not matter. That is what the court will answer. But let me give you an answer on what the court have said before. I don't know what the court will say now. Before, the court say INEC regulation and even guidelines and circulars have constitutional flavor. They flow directly from the Constitution for conduct and free and violation of those guidelines and rules is a violation of the Constitution. And the court went further to say INEC officials are bound by the guidelines and regulation. Here, it is not the parties. It is INEC himself. The violation people are complaining, which you said is the perception, is the violation done by INEC, not the political parties. So they are the ones who interpret, go to court. I think there are also parties in the cases, and that's why I cannot call for that. They may have their defense, which they will give to the noble judges of the Court of Appeal, who is the tribunal, and even up to the Supreme Court as to why they made regulation and they refused to comply. And Supreme Court will look at it, why they will deviate from their previous decision that says INEC staff ought to comply with their guidelines mandatorily. So let's see how it plays out.
Well, sir,
they may have a justifiable reason.
Part of the feedback from this electoral process, February 25, March 18, April 15 supplementary election, has been the demand by the civil society that we need further reforms with regard to electronic voting, with regard to the Electoral Act 2022, with regard to even the appointment of resident electoral commissioners, having seen the rogue conduct of a resident electoral commissioner in Adamawa State. But looking at it generally, holistically, what are the kind of reforms that you would recommend to say, look, our journey, electoral reform, we still have a long way to go, or we are fine? What would be your recommendation?
Well, my perception, this is personal, with respect. We have tampered with our laws of election frequent, even in the Constitution. So frequent that any slight problem, these are human problems. Even if you make any amendment, it is punishment given to those actors that will create a deterrence. It's a human problem. The present electorate is fair enough for a person who wishes to do the right thing. We do. But a person with an evil mind and who is bent at violating the law, like the resident electoral commissioner in Adamawa, who gave the damn consequences, insubordination to his staff, because insubordination to his chairman who appointed a returning officer, insubordination to the Electoral Act, and a deliberate violation of the Constitution. Such people, no matter the kind of reforms they do, if they spring out, the only remedy that will create a deterrence is punishment, severe punishment to such people. If you go down and say you change the method, you bring any other method, and such kind of deviant person comes in to play that role, will you change again? This has been the problem. This is an isolated problem. To me, on this particular issue, there shouldn't have been a further review, but the law should take its course. My learned brother Sikh, Falana SN, gave provisions in the Constitution that can deal, in the Electoral Act, that can deal decisively with the kind of attitude the man did. If you follow the Electoral Act, he will go to jail. And he does not have option of fine. He stays there. He knows that no other resident electoral commissioner will carry out the kind of thing he did. That's one area. But I have already previously given you a general overhaul of the electoral review that we felt is desirable. And I gave you explicit areas I feel we could interfere with. First, the issue of preliminary objections in pre-election matters should be heard together, compulsory, and judgment given together, compulsory, both from the preliminary objection on merit, so that people should not be shut out. 180 days is specified at the trial code, and in pre-election matters, people started devising means that are really unconstitutional. Pre-election matter will be filed, the trial judge, within his wisdom, will take argument together with the preliminary objection. When either the 180 days is utilized, either remaining 5 days, the judge will come in and give one-page judgment and say, I struck out the man's case is incompetent. He did not talk of the merit. He can't go to Court of Appeal. Court of Appeal say, look, your 180 days has passed. If I remit the case for hearing, you will still not. So this thing dragged on until the last judgment. I was in the Supreme Court. His lordships, in their wisdom, they were very worried. His lordship, Honorable Justice Okoro, said he will take this matter up because he noticed that all the pre-election matters that ought to have merit were struck out of technicality. And they were struck out at a period 180 days have passed. They feel the pain, but their hands were tied, there was nothing. So that is an area we need to do a reform, a minor reform. You must, as a court of first instance, give your judgment on the technicality along with the merit of the case as if the technicality does not exist. And if at the end of the day, you are dismissing the action by upholding the technicality, the person will have a merit to go on the Court of Appeal. And if you are reverse the judgment, he will have justice. This is one area I told you. I told you also, to me, I did not see any special need why governorship elections should go to the Supreme Court. When I was Attorney General, when the First Amendment was done, I did not. I refused. Because elections are done on 2 tiers. In all other elections, it's 2 tiers except governorship. President starts from the Court of Appeal as the Presidential Tribunal to Supreme Court. Senators, House of Rep, and House Assembly come from the Tribunal to Court of Appeal. So why is the governor special species that you have to start from Tribunal, Court of Appeal, then Supreme Court, 3 tiers? This is clearly something that is not in the best interest of the country. The Supreme Court became overwhelmed.
Mr. Aondoakaa, while you're speaking about electoral
how are you?
reforming the electoral process or your recommendations for reform, we're about to wrap up now, but I would like you to speak to another issue around that reformation in terms of appointment of officers. So in terms of the INEC chairman, resident electoral commissioners, because this was part of the issue that was raised following the Adamawa situation. What's your recommendation on that note?
Thank you. I thought you were going to attack me directly because Justice Ware's Commission of Inquiry was sent to the Federal Executive Council,
yes,
and I was the chairman of the subcommittee to review it. And I issue of appointment of our next chairman by the Chief Justice, I removed it, and I think it should be president.
So would you stand by your?
I think you are trying indirectly to. Let me explain my position.
Okay.
Why I did that was it was the same fear of bringing in the Chief Justice into an area that will damage the judiciary. For instance, now, the accusation against INEC and specifically directed to the chairman could by extension be extended to the appointing authority. There's no doubt that if you say the man has compromised, that even if you don't voice out, you have a feeling that the appointing authority tolerated it. And I've felt that, again, if INEC chairman is appointed by the Chief Justice, and in all electoral matters, petitions, he is a statutory defendant, I can't see how it will come back to him again. So he will be a judge in his cause, because he is the person that appointed. And these were the key areas I felt that the judiciary is our last hope. So let us give them an independent air so that anything that comes in there, they will knock it down without thinking that I am the one who appointed. Before you appoint somebody, you, the person doing the appointment, must be satisfied the person is of good character. And if at the end, the person is of worse character, the first person to blame will be the person who did the appointment. And I felt everybody in Nigeria, the overall savior, the judiciary will be our savior. Even if the president does do the appointment and the person appointed does the wrong thing, it will go to the judiciary to do the right thing. And what they do will affect the president because his judgment in doing the appointment was wrong.
All right.
That was my reason. And I still maintain the reason that it is still better for the president. After all, is it not the president that appoints the Chief Justice of Nigeria? And then there will be also a power struggle. You appoint, then you go back to the president and start asking for money for funding these officers. This was the conflicts that I felt that Nigerian system, you do the best thing, but people will introduce a new factor.
Yes.
If the Chief Justice does the appointment of the president or the chairman of the INEC and the resident commissioners, and then when issues of money comes, you go to the president. I wonder what, he said, that person the Chief Justice appointed, it's not our man. Then they'll start starving the funds. So I feel it is better for the judiciary to be isolated to knock it off. I may be wrong, but that was my perception.
All
And I
right.
still maintain that position that the appointment is not the issue. It is the people who are there. When they change like chameleon, the law should follow its course.
Well, thank you very much, Mr. Michael Aondoakaa, for your time this morning, former Minister of Justice and Attorney General of the Federation.